One day, at another time, a girl will unearth the civilization that has been buried deep for so long. See you on that day.
Ladies and gentlemen, our opening ceremony is about to begin. Please stay inside the Zoom meeting and make sure to turn on your camera. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you. Alhamdulillahirabbil alamin wa bihi nasta'in wala umurid dunya waddin. Wassalatu wassalamu ala asrofil anbiya'i wal mursalin wala alihi wa sahbihi ajmain amma ba'du.
Good morning, ladies and gentlemen. Today, on the 22nd of March 2024, marks the 5th day of the Faculty of Law and Master of Notary program of Yarsi University International Short Course 2024, entitled The Dynamic of Indonesia Legal System, Challenges and Opportunities in 5.0 Society, with the two focus of discussion being Introduction to International Arbitration and
the comparison of contract law between civil and common law. This event was organized to help participants who are interested in law to seek the opportunities and challenges in 5.0 society within legal aspect, the urgency of legal reform, contract law in 5.0 society, and arbitration in dealing with 5.0 society.
First of all, let's express our gratitude to Allah Subhanahu wa Ta'ala for the endless blessing which allow us to participate at today's event in great condition. We also convey our sincere prayers and greetings to the Prophet Muhammad Sallallahu Alaihi Wasallam, whose intercession we await in Yaumul Qiyamah later. Amin ya Rabbal Alamin.
Before we start, we would like to mention some of our most honorable guests today. The founder of Yarsi Foundation, Professor Dr. Journalist Udin PAK, the chairman of Yarsi Foundation, Professor Dr. Shanti Journalist SPA MCAS, Director of Yarsi University, Professor Dr. Fasli Jalal PhD, the Dean of Faculty of Law of Yarsi University, Dr. Muhammad Rian Bakri, SH.MH.
The Director of Yarsi University Postgraduate Program, Professor Dr. Chandra Yoga Aditama, SPPK DTMNH, MARS, DTCE FISR. Deputy Dean 1 of Faculty of Law, Yarsi University, Dr. Liza Evita Jakfar, SHM, the Head of Master of Notary Program, Dr. Chandra Yusuf, SH LLM MBA MMGT, and all the participants who still have the spirit to catch up with our exciting agenda today.
Before we move further into our event, let's introduce ourselves as the Master of Ceremony. My name is Marsyani Solia Rahman, and here is my partner,
Adara Oleh Riyadit.
We will guide you from the beginning until the very end of today's event.
Ladies and gentlemen, in this morning we have several agenda to follow. First, the opening of Yarsi International Short Course Program 2024. Second, reading the moderator's resume. Third, the presentation of our first topic, Introduction to International Arbitration, which will be presented by our great speaker, Professor Dr. Harlan Sipel, MBA. Fourth, the discussion. Fifth, a photo session. Then we'll have 1 hour break to end off our morning session.
After that, we will continue with the presentation of our second topic, the comparison of contract law between civil and common law, which will be presented by our another wonderful speaker, Dr. Chandra Yusuf, SH LLM MBA MMGT. Then we will have a 30-minute discussion before lastly photo session.
Right, everyone. Before we start our first discussion today, let's check out our moderator's resume first. Mr. Dodi Pranata Wijaya, SHLLM. He has a master's degree in law at the Michigan State University, United States of America. He's currently on a scholarship program from Indonesia's Ministry of Finance for his doctoral degree. His teaching focus and research interests are on international law, constitutional law, and public policy politics.
Now, we are coming to our main event, which is the discussion of Introduction to International Arbitration, which will be led by Mr. Dodi Pranata Wijaya. To Mr. Wijaya, the stage is yours.
Thank you, Adara and Marcia. Hello, everyone. Good morning, ladies and gentlemen. Friday is our last day session of Yarsi International Short Course, and I'm very delighted and honored to be a moderator today. Because today we will have some lecture, and this first lecture in the first class about the introduction international arbitration from such an amazing and very capable lecturer to discuss with. His name, Professor Dr. Harold Sipel, MBA. He got Magister Juris from University of Linz, 2007, and he did a Master of Business Administration in Seoul National University, and also he also pursued his study in doctor in University of Leeds, come back to the University of Leeds, 2010. And also he did a postgraduate diploma in international arbitration, Queen Mary, University of London, 2012. And he also holds some professional certificate, such as a certificate in supply chain management in Roger University, and also certificate of compliance in the University of Pennsylvania, and also certificate in the materiality of ESG factors in University also in Pennsylvania. So why do I say he's very capable of this issue? Because Professor Harold is an Austrian qualified lawyer and foreign lawyer that admitted to the Malaysian bar who heads the firm's European desk and Northeast Asian desk. He is an experienced counsel in international arbitration who has represented clients in complex commercial and investment disputes. He does a lot of international arbitration. I read his resume is very magnificent. Professor Harold was also head of legal services at the Asian International Arbitration Center, where he oversaw the administration of approximately 300 arbitration. And fun fact about Professor Harold, he can speak 5 languages, Germany, because he's native German speaker, English, French, Italian, and Korean. So it is very capable. And for information for all of you, that today we have participants who are from 7 countries join this event for today. Australia, Philippines, China, French, Somalia, and India, as well as Indonesia. So if Indonesia includes, so 8 countries joined this event. So without further ado, please welcome Professor Dr. Harold Sipel, MEA. Time is yours.
Thank you very much, Buck, for this overly generous introduction. I must also apologize for starting a bit late. I'm currently based in Germany just for this week, and it's now 4 a.m. And when I turned on my computer this morning at my hotel, suddenly the internet didn't work. So I needed to call someone from the reception up here. And you can imagine that at 3:20 a.m. when I realized that I have issues, this takes a bit of time. But I'm here. Selamat pagi. I'm very glad to be here, and I'll move immediately into the topic of international arbitration because we don't have that much time since I was late a bit. Let me just share my screen, please, and I hope this works now because the technician is gone. But I can see that this works. So I'll speak very briefly about international arbitration. It's just an introduction. I run a full semester course at Keio University in Japan every semester. But I'll try to highlight to you the most important parts and features of international arbitration. So to those of you who have not heard about international arbitration, it is all about resolving disputes. So two companies, let's say, have a dispute. What are they going to do? And when we look at arbitration in general on how to resolve disputes, we have a full spectrum that's available to us. Let me highlight this to you. We could start just negotiating, meaning we don't go to court, we don't go to arbitration. It's just between the parties themselves. They discuss and they try to find a solution to the dispute they have. We could also do a mediation, which is completely different from arbitration. In a mediation, at least the way it's done in the Western world, you have a third person. On that picture, that would be the green person here, who will leave it to the parties to discuss and find a solution and only facilitates the discussion. But that person traditionally does not even suggest a solution. This is similar to conciliation, but in a conciliation, typically the person who is mediating between the parties, conciliating between the parties, also suggests a solution. So you can see I deliberately chose a different picture because the green person here for mediation says, oh, it's up to you. But the red person, if you can see, seems to push those two parties a little bit. And that's the main difference without going into details at all. You could have expert determination. This is particularly suitable when the question is not a legal question, but rather a question of facts. Imagine that my construction company comes to Indonesia to build a huge hydro plant, a hydropower plant. And then there is a technical issue. Now, legally, it's quite obvious, right? Is it an issue of warranty, yes or no? But what's maybe not so obvious is the factual question. Is there a defect or is there no defect? So then we may call in a technical expert who looks at everything and then comes up with a determination. We have adjudication. This is a process that exists in Indonesia only in a contractual way. In some countries, you have statutory adjudication. Malaysia is one of them. So in Malaysia, it is all about construction disputes and only payments in construction disputes. And I'm not going into details because we don't have time, but I just want to highlight that this is also one possibility. We have arbitration, which I will discuss today, and we have litigation, which is going to court. And when you look at the bar here, you can see we start with negotiation on the very left. And the further you move towards the right, the more litigious it gets. Litigious here as the more the parties are fighting. Um, it's my experience, having done several dozen arbitration, that it can also be quite intense, but typically there is still more room for settlement in comparison to a litigation. This is my experience. This is why I put arbitration further to the left in comparison to litigation. Well, and if you pay attention, you will also see that there are two more little bars here on our line. You can also choose not to do anything about the dispute. Let's say I have a company and I'm supposed to deliver you my products, and you make a 50% down payment, and then I run away. You can decide not to do anything. And at the far end of the spectrum, you can also fight. And unfortunately, I don't recommend it, but unfortunately, some people do it. You know that from the movies. Someone borrows money and doesn't pay it back, and then they send someone with a baseball bat. Now, that's not usual for companies to resolve disputes, but I want to highlight that sometimes this happens. But what is arbitration? Because going back, you can see there is a full spectrum, and we only speak about international arbitration today. What is that? There is a neutral third party, which is the arbitral tribunal, and it determines a dispute between two or more parties. So compare that to mediation, where I said the mediator leaves it to the parties. Here, that third party, that neutral body, determines the dispute, which means it decides the dispute. This is not someone who makes a recommendation. This is not someone who will discuss with the parties, do you prefer this, do you prefer that? This is someone who says, oh, I decide. There is a binding decision, not just a recommendation, and it's an enforceable decision, meaning you can go to court and you can ask a court to assist you. Now, this is one of the most important differences between arbitration on the one hand and litigation on the other hand. An arbitral tribunal has most powers that a court also has, but it does not have the power to enforce. This is always left to the domestic courts. So you must be aware of that. But the decision is enforceable, which means you can go to the courts and ask for help. However, if, for instance, you merely negotiate a settlement, then you cannot go to court and simply ask the court to enforce that. You will first have to litigate, and only then, once you get a judgment, you can enforce it. So that's a huge difference. And this neutral third party, this arbitral tribunal, exercises judicial functions. Now, what do I mean by that? That's a big term. Just understand this to mean that the arbitral tribunal, in many ways, is like a judge. That's what you need to know, and this is what judicial functions here would mean. Now, what types of arbitration exist? We can differentiate between domestic arbitration, two Indonesian parties, two Cambodian parties, two Australian parties against each other. Or it doesn't need to be two, there can be more than two parties. Let's say you have two claimants and 5 respondents. So 2 parties making the claim, 5 parties defending themselves. This is all fine, but in a domestic arbitration, they all come from the same country, one single country. In international arbitration, there must be some international element. So usually the way we define it is that the parties come from different countries. But it's not always so easy to distinguish. Imagine a situation where there are 2 Indonesian companies, and they both set up a subsidiary abroad. One does so in Australia, and one does so in Malaysia. Now, these are small subsidiaries and they are parent companies in Indonesia. They still control everything. Now, if on paper these two companies fight, we have one Malaysian versus one Australian company, but in reality, they are both Indonesian, right? Because they are subsidiaries and they're still controlled from the headquarters. So it's not always so easy to distinguish, but this really depends on the circumstances. We can also differentiate by subject matter. That is, what is the arbitration about? We have commercial arbitration versus investment. We have sports arbitration, maritime arbitration, and many other types we can distinguish. I do not have the time to go into these in detail. If you're interested, simply ask Professor Google and type what is sports arbitration or what is maritime arbitration, and you can find out more about these. Finally, we have institutional arbitration versus ad hoc. In an institutional arbitration, you have a specific body, which is like a private court, if you want to say so, that helps with the administration of the arbitration. If it's ad hoc, you lack this body. And it's done entirely between the parties and the arbitral tribunal. Now, going back to our dispute resolution spectrum, you can see that there are many possibilities and many options that parties can choose to go to arbitration. And generally, they don't need to go to arbitration. There are many options to also choose other forms of dispute resolution. But why do they go to arbitration? That's the question here. In some instances, and these are typically the less developed countries, there are slow courts, and therefore you go to arbitration because it's much faster. Now, I understand that this used to be the case in Indonesia in the past, a long time before Indonesian courts became very efficient. I understand that this is still the case in many African countries and also in a few other Southeast Asian countries. But as countries evolve and as our systems become better, like in Indonesia with the court system, the slow courts do not really exist that much anymore. So this becomes less and less of an issue. This is different for international dealings. The biggest advantage is that you have almost worldwide enforceability. Remember before I said you have a judgment, an arbitral award, and you cannot enforce it yourself. You need to go to a court. So this is the enforceability. I will speak about that in greater detail just now when I highlight an example to make this better understood to you. Imagine that you have a company and that I have a company and we enter into a deal. So here is our two countries. Apologies for those who are not from Indonesia. You need to live, you need to imagine that you are Indonesian now. So the Austrian flag is at the top and the Indonesian flag, as you know, is on the bottom. And you understand that suddenly you Indonesians have a great interest for the traditional Austrian fashion, the lederhosen, which you can see on the right. And by the way, if you know about this and know it from maybe the Oktoberfest in Germany, they took it from us, so we had it first, not the other way around. But you realize that these lederhosen are becoming very popular in Indonesia, and you want to import them to Indonesia. So we agree on a shipment for 200 juta, right? 200 million Indonesian rupiah, and you make a down payment because I say, look, I need to produce all these lederhosen. I need some money first, right? Because else it's too expensive. So we make a down payment and we agree that after I receive the down payment, I will start production. And then within a few weeks, I will ship the lederhosen to you. And once you receive them, you make the other 50% down payment. But I say thank you, and I just run away with your down payment because I'm a bad guy. Sorry about that. You made a bad deal. So what are you going to do? You will want to get your money back, right? You will want to get your 100 juta back, your 100 million rupiah. But when you look at our contract, it says Jakarta District Court. So since I don't react to your demand letters and your emails, you sue me at the Jakarta District Court. And to those of you who are Indonesian, you would know that these days in Indonesia, proceedings before courts are rather swift. So after about 6 months, you win at the Jakarta District Court. And you have this wonderful verdict. You are very happy because it says you won and I need to pay you back the 100 million rupiah together with interest. So you're happy. That's exactly what you wanted. And you send me the verdict and you say, please pay now. Look, we already asked you, now you lost. You already have to pay a lot of money. Please pay. But since I am a bad guy, I still don't pay. So what are you going to do now? You have no choice but to ask the courts to help you. But how do you do that? My company is in Austria. So you have to go to Austria for enforcement because this is where my assets are. Now, it doesn't help you at all if you ask the Indonesian courts to enforce the judgment because I have no assets in Indonesia. You know, I only go there from time to time for business meetings and maybe to lecture at university. How are you gonna take anything from me? I mean, you can maybe take my wallet once I enter Indonesia, but I never carry any cash. So you won't get your 100 juta unless you go to Austrian courts. And you go there and you go to the Vienna District Court because in Vienna is where my company is registered, and you show them the verdict. But then they say, oh, sorry, this is in Bahasa Indonesia. Please translate it into German. So you translate it, you go to a public notary. And by the way, they are much more expensive than they are in Indonesia. You incur already maybe at this stage a few juta just to get a certified translation. And you come back with a certified translation. You go to the court again. And then the court says, sorry, we don't recognize Indonesian verdicts. Because we are an Austrian court, and if you were from the EU, we could help you because we recognize judgments from within the EU, but not from Indonesia. Sorry. So now you went all the way through the court proceedings in Indonesia. You made a translation, and you also went to the Austrian courts to enforce the judgment. At this stage, your costs are probably at least 70 juta already, 70 million rupiah. Because all of this is very costly. You need the legal fees, you need the court fees, you have the notary fees, etc. But you still have nothing. So you still did not get your lederhosen that you ordered, and all you had to do was pay a lot of money. So this is very bad, right? This is where arbitration comes in. And sorry, I meant you can go all the way to the Austrian Supreme Court. This is the picture of the Supreme Court. You still won't get your money because Austria is not going to recognize a judgment from Indonesia. This is where arbitration and its key strengths come into play. Now, arbitral awards, or rather foreign arbitral awards, can be recognized by other countries. There is an international treaty called the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And the New York Convention comes into play here. Just to clarify, when I say an international treaty, what I mean is it is something, a treaty that countries sign. So Indonesia, for instance, has signed it. Malaysia has signed it. Australia has signed it. France has signed it. And I forgot the locations of the other students. I think Vietnam and Cambodia also. But all of these countries from where you are have signed this international treaty. And what does it say? It obliges domestic courts, so courts like the Vienna District Court, where you came for enforcement, to recognize arbitration agreements. They must also recognize arbitral awards, and they must enforce arbitral awards. So what does that mean? It means if you and I have an arbitration agreement and I try to sue you before the Jakarta District Court, the Jakarta District Court must say, no, you cannot engage in litigation here because we have an arbitration agreement. This is the first part. They recognize the arbitration agreements. If there is an arbitral award, you can register it in most countries. If such registration process exists, that's the recognition. And you can then enforce it. You can say to the court, please help me. I have this verdict, but they still don't pay me. Please help me. Now, currently, if I am not mistaken, there are already 173 signatories. And you can see from the map only a few dark blue spots exist. But to the best of my knowledge, if I recall correctly, you can see one dark blue spot here in the right bottom, that's Papua New Guinea. But if I'm not mistaken, Papua New Guinea by now has already signed it. So it's practically possible around the world. So to go back to our example of the Austrian Lederhosen, our contract said Jakarta District Court for all disputes. Had this been an arbitration clause that had said, for instance, arbitration before BANI, the major arbitral institution in Indonesia, then it would have been possible for you to bring that arbitral award to the Vienna District Court, and they would have recognized and enforced it. So you can see one huge advantage here in international dealings. In almost every country around the world, you can enforce arbitral awards. There is also the neutrality of the decision maker of the arbitral tribunal. What is meant by this? Now, we go again back to our example, your Indonesian company and my Austrian company. Imagine we negotiate on where to resolve disputes. And I say, I want to go before Austrian courts. You say, no way. Then you say Malaysian courts or Indonesian courts, and I say, no way, because I want a country that I'm comfortable with. So there is no middle ground, right? It's very difficult. But if we have an arbitral tribunal, nationality really doesn't matter much because it is not based in a specific country, and you can have various different arbitrators on the arbitral tribunal from who have different nationalities. I can give you an example. at this moment, two of the cases where I had to do something as an arbitrator just this week, where I'm appointed at the moment. In one case, I act as sole arbitrator, and one party is from Sweden, the other one is from Korea. But I am the arbitrator. So I have nothing to do with Korea, I have nothing to do with Sweden, right? And in another arbitration where I had to send something in writing just this week, I act as the president of the tribunal. One party is from the UAE, the United Arab Emirates. One other claimant is from Singapore, and the respondent is also from Singapore. Now, we have one arbitrator from Denmark, we have one co-arbitrator who is from Malaysia, and I, as the president of the tribunal, am from Austria. So you can really see that there is no, it doesn't play a role because it's not linked to courts who are institutionalized, who are usually closer to companies from that country. But that concept doesn't really exist in international.
So hello everyone. It's like our speaker just uh lost the connection, I guess. So we just waiting for him. He tried to uh, communicate with Professor Harold. So please kindly to wait until they can fix the problem. So while waiting the speakers, so for everyone who hasn't filling out the attendance yet, please fill in the attendance link that we already give in the WhatsApp group. So, following attendance, you may see in chat Zoom meeting that you can fill in the attendance right now while we are waiting for our lecture. And for quiz 6 and 7, we will set up the time until 6 p.m. And then for final exam, then we will inform you after the last session from Dr. Chandra lectures. Okay.
Do I
Okay,
have
here we
to?
go.
Yes, my
Yes.
apologies.
So it's fine. We know the
Unfortunately,
circumstances.
yes, unfortunately, there is little I can do here at in the middle of the night. Please accept my apologies.
No, sure, sure. So what time is it now in your
Um,
country?
right now it is 4:30 a.m.
Sorry. Okay. So you can continue, sir.
But that's okay. I
Okay.
apologize. I am just waiting to load the PowerPoint presentation. I had to restart my computer,
Okay.
um, but I should be there as soon as possible. So I understood. I think I left off discussing language. I think you understand that if you go before domestic courts, be it Indonesian courts, be it Vietnamese courts, be it Australian courts, be it French courts, you can only do disputes or you can only do the proceedings in the language that is spoken in that country. You cannot go um, to Jakarta and say, hey, by the way, I would like to do my proceedings in French. That's just not going to work. And it doesn't work for English either. Like, you cannot say, hey, I'd like to do my proceedings in English. So, as a result of this, language is a very important factor in international arbitration because when you have parties from two different countries, you do not want to end up in court having to speak the language from just one country. Let me go back to my slide. Just one moment, please. And I think I should be good. And again, I apologize. Unfortunately, this is outside of my control. Okay, I think you can see this. So the language can be chosen by the parties. And this is a huge advantage because if we are from Indonesia on the one hand and from Austria on the other hand, then English is very likely going to be our common language. In international arbitration, you can freely decide on the language. You can even say in the arbitration agreement, the arbitration proceedings shall be in English. However, um, every arbitrator must also speak either Indonesian or German. You could say that. I'm not sure it's a good idea because then maybe you limit yourself to some extent, but that's a different story. My point here is you can really agree on anything. I recently came across an arbitration clause that said the sole arbitrator, there was a sole arbitrator, the sole arbitrator shall be very well acquainted with English law and be a Japanese native speaker. So you can even mix it if you want to. But the bigger advantage here is that you do not need to have proceedings in the language of the court. I think that's the most important message here. Whether you can add some preferences, I think that's not so advantageous, but in an international setting, to be able to choose the language, that's a huge advantage, especially if we are from these two countries, from Indonesia on the one hand and from Germany on the other hand, or Austria, sorry, in my case. I'm just based in Germany at the moment. The procedure can be decided by the parties in international arbitration, which is another huge advantage. What do I mean by that? If you are in state courts, then it's the proceedings are fixed. You have the code of civil procedure of whatever country you are in, and this will decide how things are going. And you cannot deviate. You cannot say, I would like, to do things in this way rather than that way. That's just not possible before state courts. Again, if you go to international arbitration, you can decide freely. And you may think, okay, what's the point of this? Well, the point is that every dispute is different. And ideally, if you have the possibility to adjust everything according to how you want it and what is best for this dispute, then arguably it will be much better how you resolve the dispute. It will be more efficient, right? So this is why it's another advantage of international arbitration. There is also the privacy of the proceedings. What do I mean by that? Now, privacy or confidentiality means that no one knows about it. I can give you one example here. This was on the news in February 2022, and I acted in this arbitration as the Ministry of Defense's lead counsel. And suddenly all of this is on the news. Although it was an arbitration, this is at the enforcement stage, and then of course it becomes a public record. But do you think that the Minister of Defense of Indonesia wanted all this information on its dispute be out there, freely available? Of course not. So in an arbitration, it's always behind closed doors, so no one knows about it. Many countries by now even have a law that says if you go to court to enforce the proceedings, then this can be done in closed court, not in open court. Meaning, even if you are very interested in the matter, it's impossible for you to find out about it because you cannot attend the court proceedings. So then really everything is confidential. And imagine that you have a company yourself. You would certainly want to be on the news, but not because you have a dispute, right? This looks very bad. Your business, your business partners are going to say, "Oh, that's strange. Why is she fighting? Why is he having a dispute?" So you want to stay out of the news for those things. And since arbitration is confidential, and since arbitration is private, you usually do not hear anything about these things, except for when it comes to the enforcement stage, as was the case here in Indonesia. But as I said before, in now several countries, even that parts can be behind closed doors. Arbitral awards are final. Now, if you go to the Jakarta District Court and you are unhappy with the decision you get, you can still appeal. And you can ultimately go still all the way to the Supreme Court, right? And this lasts a few years because 3 courts, obviously, it will last for 3 years. This option does not exist in international arbitration. You have one and one shot only, so to say, and there is no appeal. There is something called setting aside, where for very limited grounds you can remove the award, but this is on very limited grounds, and in usually about 95% of all instances, it is unsuccessful. So you typically only have one single round of dispute, so to say. This is the arbitration. Once you have that final award, that's it. You can directly go to enforcement. There are several other reasons. We don't have time to go into all these, but this is for you to know that there are many reasons to go to arbitration. All the while, I'm someone who specializes in international arbitration. I don't want to give you the impression that this is only something that is advantageous. Now, there are certainly many disadvantages as well when it comes to international arbitration. What a lot of people have complained about in recent years is that arbitration has become very costly. Many people have also complained about that arbitration is now taking too long. And it's funny because in the past, we would resort to arbitration because it was faster than domestic courts. This is not always true anymore, especially when you have an arbitral tribunal composed of 3 people. It takes a very long time to establish the arbitral tribunal. Also, when you have an issue with an arbitrator, the replacement of such arbitrator can take a very long time. And this does happen from time to time. I currently act as counsel, not as arbitrator, but as counsel in a dispute where the sole arbitrator just resigned. Just resigned is incorrect. He resigned about 2 weeks ago for health reasons. So he said, sorry, I'm no longer able to do this. And now the parties need to find a replacement. And finding this replacement is taking forever. It already took 2 weeks. And when we look at our pace, when we look at how quickly or rather how slowly we do this, I know that it will take at least another 4 or 5 weeks until we have an arbitrator. So in the meantime, nothing happens because there is no one who can take any decision. So you can see from this that there are disadvantages to arbitration. And I don't want to give you the impression that everything about arbitration is perfect. But nevertheless, what you see on the screen, these are the main reasons why companies resort to arbitration. And you should also know that when it comes to international dealings, as we have them in my example, one Indonesian company, one Austrian company, then the typical way to resolve disputes is still by arbitration. It's sometimes arbitration and another form of alternative dispute resolution, like mediation or negotiation, but there is almost always an element of arbitration which is involved. Now, let us move on to key concepts in international arbitration. One key concept, and maybe as a starter, it's impossible to discuss all key concepts here because there simply is not enough time. And I trust that you will understand and appreciate that. But let me just highlight a few key concepts. The first one is the separability doctrine, which says the arbitration clause is as though you cut it off, and it's then a different contract within your agreement. Why is that necessary? Well, imagine that you and I have a contract and it contains an arbitration clause, and you're very happy about this because you want to sue me, right? And you want to go after me, and you don't want to go to the Jakarta District Court or any other court for the reasons we just discussed, right? But then I realize, oh, now I may get sued. So I could try to be very smart, and I could simply terminate the agreement. Now, if I terminate the agreement, I also terminate the arbitration clause, right? And there is no more arbitration clause, and you have to go back to the courts. But here, the separability doctrine comes in, which says even if you terminate the agreement, the arbitration clause, which is a separate contract, still exists. So you can still sue me and then sue me for wrongful termination, for instance, of the contract. There is competence, which basically means the competence or the authority to decide on your own authority. The arbitral tribunal and not a court can decide on its own jurisdiction. Now, why is that important? Imagine that you are in a dispute and you are the one who is the respondent, the defendant of the case. You will try to fight and not lose, right? And the best way to do this is to say, no, we shouldn't even be doing arbitration. Because if you say this, then you don't even go to the merits, and you can already fight this at this preliminary stage. Now, if it were necessary to go to a court to decide on these matters, on jurisdictions, it would greatly delay the proceedings. In the meantime, a lot of money is spent, and maybe the party you go against, the claimant, will lose interest or will give up, and you can reach a very favorable settlement. So this is why competence is very important. We spoke about already replacing arbitrators. I told you the story of this one arbitrator who got sick. And let me speak about the people very briefly who decide in arbitration matters, the arbitrators. It's not like in a Western movie, but it can get very nasty. So please do not think that anyone gets shot, as in the movie here, but it can be very nasty. In principle, any arbitrator must at all times be impartial and independent. And when there are justifiable doubts as to the arbitrator's impartiality or independence, then you can challenge the arbitrator. So these are very broad concepts, and it's very difficult to say when exactly is there a justifiable doubt. You must also keep in mind that from country to country, from culture to culture, maybe in Indonesia, even from island to island, it really depends on perception. What is impartial? What is independent? When is there an issue? Now, I am quite sure that there is a huge difference between how someone from Lombok in Indonesia looks at this and someone from Bali looks at it. Or maybe I can also say someone from Jakarta or someone from Bandung. There will be different perceptions, but this is then up to the court to decide. You can ask yourself, do I think this is an issue, yes or no? And it may not necessarily get you the right answer, but you may get a feeling. Let me give you an example. In principle, you can decide anyone as an arbitrator, as long as this person is impartial and independent. But what if the person you appoint is a very close friend of yours with whom you go to play tennis once a week? Is that person still impartial or independent? An issue. What if the person you want to appoint, what if she has a 5% shareholding in one of the parties? What if the person you want to appoint clearly hates one of the counsel of the arbitration? And you know it, for instance, because they had a public fight. So there are many issues where maybe you don't know the answer right away. And I will say it depends. But there is a wonderful guideline out there, which was just renewed now and is in its third edition, if you want to say so. There are no editions really, but it's now the second time that this has been updated. And this is the IDA guidelines on conflict of interest in international arbitration. So if you ask Professor Google for this, you will get the answer. And you can then simply look up what circumstances exist. Now, when someone is successfully challenged, which means when you say this person is not impartial or independent, and I challenge that person, when that challenge is successful, then the original arbitrator must be replaced. This is the same as in my example that I gave just now of my arbitration, where the arbitrator resigned because he was sick. It's the same situation. The arbitrator must be replaced. And then you will be getting a new arbitrator. But as I said, this can take some time. Now, I speak about very broad concepts here: arbitration, arbitrator. Who is acting in an arbitration? I'd like to briefly highlight those things. And I can see that someone on the chat wrote, please ask questions. And yes, absolutely. Please interrupt me at any time. Since I am here on literally the other end of the world and not in a classroom, I do not see if anyone has a question. So you don't even need to wait for the right moment. Please just interrupt me by turning on your microphone and saying question, or type the question into the chat. I'm very happy to answer any question you have. So who acts in an international arbitration? We have the arbitral tribunal, who we already discussed, and we have the claimant and the respondent. This is how we call them in international arbitration. We don't call them plaintiff and defendant. We call them claimant and respondent. Keep in mind that these days, very often, we have multi-party arbitrations. So you have more than one claimants and or more than one respondents. You then very often have something which you are probably not familiar with, if you know litigation only, tribunal secretary. This is usually a lawyer who acts as an assistant to the arbitral tribunal, assisting the arbitral tribunal mainly with administrative matters. We then have also witnesses, and very often in international arbitration, interpreters. Why very often? Well, because it's international arbitration, right? And it happens very often that the people who are involved do not speak the language entirely fluently, and then you need an interpreter. And what we also have, and I don't know if you have this in Indonesia, we don't have it in Austria before court proceedings, usually. We have a court reporter. This is a person who will transcribe everything. The way I put this here on the screen is deliberately chosen because this is usually how you would be seated in the arbitration. So you have the tribunal on the one end, and then the claimant and the respondent on each side facing each other. The tribunal secretary usually sits next to the tribunal. And before the tribunal, you have the witness and also the interpreter. The court reporter usually sits somewhere else, like a little bit on the side. And sometimes the claimant would sit on the other side, sometimes the respondent. This is based on my experience in international arbitration. There is no right or wrong. It can really happen either way. Now, who are these actors? We also have and sorry, how does it work in practice? Usually, what happens is that the claimant will file a request for arbitration, which means I now want to commence an arbitration, and will send it to an arbitral institution. In my case, I chose the ICC because this is by far the best known arbitral institution around the world. The arbitral institution will receive this request for arbitration and will send it to the respondent. They will basically say, oh, look, we got this from the claimant. Here is the request for arbitration. You now have 30 days to respond to this. This will then ultimately go to the establishment of the arbitral tribunal. So usually the claimant already in its request for arbitration will indicate, I want to nominate or appoint, depending on the arbitral rules, Miss So-and-so, Professor So-and-so, Dr. So-and-so. And the respondent, when it files the answer to the request for arbitration, will do the same. And then these two arbitrators, they will usually jointly choose a third party, which acts as the presiding arbitrator or chairwoman, chairman, president. There are numerous ways for it, but it's always the same concept. It's one presiding arbitrator, and that person will be on will form then ultimately with the two co-arbitrators the arbitral tribunal. So who is acting? For the claimant, you have lawyers acting. At an arbitral institution, you have case counsel acting. For the respondent, you again have lawyers acting. And for the tribunal, you have typically lawyers, professional arbitrators, and some other people. Sometimes in rare circumstances, this is also someone who works as an engineer, for instance, but is really well versed in resolving disputes. Many university professors act as arbitrators. I don't know if he's in any way related to Yarsi University, but you may have heard of Prof. Hikmahanto from EU, from UE, from University Indonesia. I understand that he regularly acts as an arbitrator. So you have different people acting there. Who is the tribunal secretary typically? That is a person that works in the chairperson's law firm. Someone who works with me at my firm in Indonesia, I just asked him yesterday to send his CV because I want to appoint him in this matter where I act as the presiding arbitrator. So I asked that he send me his CV because I need to share this with the parties, and then they say whether they agree to his appointment or not. And well, we also had the court reporters and the witnesses, etc. But obviously, these people, these are professionals, right? I mean, a court reporter, that's a profession just as it is to be a lawyer. And the witnesses are just everyday people from the companies that are involved. And it's impossible to say it's precisely this person or it's precisely that person. That really depends on the circumstances. Now, I mentioned before that arbitral awards are final, which means there is no appeal. You cannot say, oh, I'm unhappy with this decision because I believe the arbitrator took the wrong law and now I appeal. Or you can also typically not say, I believe that the arbitrator decided wrongly on a fact. He should have found that the machine had a defect, but in turn he found that the machine had no effect. And therefore I go to appeal. You cannot do that. You can only initiate so-called setting aside proceedings. Now, what are these? Let me briefly explain. And sorry, before I do that, in some few countries, the UK being the most prominent one, there is another way of recourse, which is an appeal on an important point of law. But I don't even want to discuss this because those are very, very few countries only. And when we look at things internationally, from an international perspective, then this remedy, appeal on an important point of law, it really does not play a large role. And in Indonesia, it doesn't even exist. So I'm not going to discuss it, but maybe it's good for you to have heard about it at least once. Now, what are my remedies? My remedies, or my only remedy really, is the setting aside proceedings. When we look at the UNCITRAL model law, and maybe just to make sure everyone is on the same page, the UNCITRAL is a department, if you want to say so, of the United Nations in Vienna. So this UNCITRAL stands for United Nations Commission on International Trade Law. This organization, among others, always comes up with model laws. A model law is basically a law that the UNCITRAL will say, these are the best standards around the world, and we encourage countries around the world to follow these standards. This is what it is. Now, from top of my head, around 80 or 90 countries around the world follow this model law, the latest model law. So you can see that in real life, it does play a very important role. And instead of only focusing on one country, like only focusing on Indonesia, I thought it's best if I explain the international standard, so to say. Now, what are the reasons? When can you set aside an arbitral award? It is when there was incapacity of a party or invalidity of the arbitration agreement. Let me give you an example. Let's say, excuse me, let's say that you have a company and I have a company. And on my side, I sign the contract. And I send it to you, but on your side, let's say just a secretary signs the agreement, not you as the company's director or CEO, but a secretary. Or it can also be someone who, in a larger organization, let's say this is the director of sales who signs the agreement. but internally, the director of sales is only allowed to sign agreements together with a lawyer. Could be something like this, right? Then you can say that there was incapacity. The arbitration agreement may be invalid if what you say cannot be done, for instance, because you speak about something that doesn't exist. So in Indonesia, the best known arbitral institution is BANI, but let's say that I say any dispute arising out of or in connection with this agreement shall be resolved under the rules of the world famous International Arbitration Court in Indonesia. This does not exist. So then the arbitration agreement would probably or likely be invalid. Another reason is that there was no proper notice of the appointment of the arbitrator or an impossibility to present one's case. Think of a situation where you are a small company and you have moved your company in the meantime. So when you receive the notice of arbitration or the request for arbitration, when you are supposed to receive it, it is sent to the wrong address. But let's say that the company who is now there, not you, but the company who rented the offices after you, they just sign off and they say, yeah, we received it. Now, everyone will think that you know what's happening because you got the request for arbitration, but in reality, you don't know anything about it because someone who is not even related to your company signed off on the delivery. This would be where you have not been notified, even of the commencement of the arbitration proceedings. There may be an issue in some limited instances where a party is not given the opportunity to present its case. And usually this is the standard. You must be given the opportunity to present your case. Think of a situation, that's the most likely situation, where one party requests that there be an oral hearing, but the arbitral tribunal says, no, that's not necessary. This case is so clear. We don't need that. In this case, there may be an issue, and arguably there is grounds to say that one party was not able to present its case. There could be that an issue is extra petita, which basically means I go to arbitration, I ask for 10 million, but the arbitral tribunal grants me 50 million or just 11 million if it's beyond what I even asked for. But if it's possible in some cases, this can be set aside, only this portion. Think of another situation where I claim for damages and that's it. And the arbitral tribunal gives me, or let's say I claim for damages for breach of contract, and I win on this part, but the arbitral tribunal also gives me damages for defamation. Now, if I never even requested damages for defamation, then how on earth should I be? Why on earth would I be getting this, right? So this is extra petita. In this case, if the damages for breach of contract are okay, if this part of the arbitral award is okay, then only the portion on the defamation may be set aside. There may be an incorrect composition of the arbitral tribunal. Now, think of a situation where you have where the arbitration agreement says there shall be 3 arbitrators. But then the arbitral institution makes a mistake and they say, no, there should only be 1 arbitrator. Then clearly there is an incorrect composition. And that's also a reason to set aside an award. And finally, the issue of non-arbitrability may arise. Now, what is that? Not everything can go to arbitration. Think of a very extreme case where someone kills someone else and then says, no, 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 I don't want to go to court. I want to arbitrate. Now that's ridiculous, right? Because especially those severe criminal law matters, they must all go to court. But this is a very extreme case. In some countries, it is not possible to go to arbitration for IP matters. Also, in most countries, it is not possible to go to arbitration for family law related matters. So if you want to get divorced, usually you cannot go to arbitration. So if then, nevertheless, the dispute goes from beginning all the way to end in an arbitration, then this would be a reason to set aside the arbitral award. These are the reasons on the Article 32, and then Article 33 has one broader statement that says if the arbitral award goes against public policy. Now, what does that mean? I believe I can best explain this through an example from Malaysia, where I usually reside when I'm not in Europe, giving a lecture at 3:30 a.m. In Malaysia, as you may be aware, Islam is the state religion. This has profound impacts also on legal concepts from time to time. And for instance, gambling is disallowed in Malaysia. So if, for instance, there were an arbitration and it related to a casino, there could be big issues in Malaysia, because just by the fact that this is about a casino itself may go against public policy. Now, it's maybe the position I'm taking is a bit extreme, but I'm sure you understand. If gambling is allowed and then the arbitration is ultimately about a gambling dispute, then that's not something you can enforce. So this would be a public policy reason. There are many cases out there, many real life examples. So you just have to look at them to find out more. It's impossible to really discuss everything here in the short period of time that I have. What are the legal consequences when an arbitral award is set aside? Well, I think we have to differentiate between two schools of thought. Two schools. The main school says, if you successfully manage to set aside an arbitral award, and please remember that this happens very seldom, maybe in 0.01% of all arbitrations. It's very difficult. But if you manage that, then the main school of thought is that the award becomes a legal nullum, which means it simply does not exist anymore. See, that's the difference between an appeal and a setting aside. Appeal basically just means there are certain points you are unhappy with and you want these points changed, right? Setting aside, imagine that you move it somewhere else, you throw it into the garbage. And this is really what setting aside means. So the arbitral award becomes a legal nullum. It ceases to exist. So as a result, when that happens, everything that you did is gone, and you need to start over from scratch. You need to reinitiate arbitration proceedings. The other school of thought, and France is the most famous proponent of this approach, is that enforcement is still possible. The award still exists because the award was only set aside at the seat, and it still exists in the international sphere out there. Now, I appreciate that this may be a bit difficult to understand for you, but because I haven't gone into detail, and unfortunately, I'm afraid I don't have time to go into this because I realize that time is already very advanced. And if you want to know more about this, then feel free to send me an email, but look it up on the internet first. You can simply write setting aside arbitral awards, and you will find out most. And with that, given the advanced time, I thank you very much for your attention. And if there are any questions now, I look very much forward to receiving them. Thank you.
Okay. So thank you, Professor Harold. So we come to discussion session right now, and I think Dr. Chandra would like to ask some questions. So please, Dr. Chandra. Dr. Chandra. Okay. Host, please unmute the Dr. Chandra's mic. Okay. Yes. Host, can you unmute the Dr. Chandra Yusuf? Because the
Hi,
host is the
Harold.
only
How are
one.
you?
Okay, good.
Hi, Harold. How are you?
Good afternoon. I'm
It's
good,
very
thank
cold
you.
out there, right?
Yes,
In Germany, it's very cold.
very cold. Yes, I'm suffering because after living in Indonesia and Malaysia for many years, I am not used to the cold weather anymore.
Okay. I want to ask about this is very important for Indonesian. Um, Indonesia has become a member of New York Convention, right? And has law number 30 and 1919 on arbitration. The
Yes.
problem is like the Singapore International Arbitration Center, SIAC, its awards are already enforceable in Indonesia. Is it possible that Indonesian National Arbitration Board, such BANI, can be enforced in Singapore, their decision? What if Singapore doesn't want to accept it? Can I have? I mean, can I info? Can there is a mediation, or can any institution that can enforce my BANI decision in Singapore? That's my question.
So thank you so much, Chandra, for this question. So in principle, the Singapore courts cannot do anything because you have this international treaty, and Singapore is bound by this treaty. So as long as there are no issues with the arbitral award, they must enforce it. It's as simple as this. Because if they did not enforce it, then this would amount to a breach of international law, because when Singapore signed the New York Convention, they also agreed that they would enforce arbitral awards. Whether they come from Indonesia or Korea or Malaysia, it does not matter, because all of these are countries that signed the New York Convention. So as a result, they must enforce it. And whether the award comes from Bani or from another arbitral institution in Indonesia, unless there is an issue with the award, they have no choice. They must enforce it, whether they like it or not. And I'm sure they don't like it, because we know how our friends from Singapore are. They only want their own thing. But they have no choice. They must enforce it. And sorry, if I may just clarify, and the same principle would apply not only to Singapore, but to any other country in the world. It applies to Malaysia, it applies to Austria, it applies to Germany. Since Indonesia signed the New York Convention, unless there is an issue with the arbitral award, one of the reasons that I stated on my last slides, then the courts of that country where you go for enforcement, they must enforce it.
Okay. Thank you.
Okay, enough.
Yeah,
Enough, Dr. Chandra?
yeah,
Okay,
it's
good.
enough. Okay, it's okay.
Okay. We have 10 minutes remain, so maybe any other question? Prof. Harold,
Yes.
now we are in the middle of 5.0 era, where almost all of our activities are connected with technology. Is there any effect to the international arbitration? If so, how much influence does this technology have in the field of arbitration? Maybe
Oh,
that's my question.
yes, that's a very good point. So I think we see discussion about technology at a lower level and at a higher level at the moment. I start very briefly with the lower level. The lower level started during the COVID pandemic, because suddenly everyone needed to switch to remote hearings. And when I mentioned the matter that I did for the Ministry of Defense of the Republic of Indonesia, back then the Indonesia requested me to come to Jakarta for the oral hearing. And even though there was a travel ban, you may recall there was a travel ban for foreigners at the moment. They would have given me a special permit to travel to Indonesia, but I could not, because I could have only gone into Indonesia, but I could not have come back to Malaysia. So at that time, I was sitting in Malaysia at home, and the entire team was sitting in Jakarta. So you can see here technology plays a very big role when it comes to these remote hearings. We also more and more have systems that allow you to simply submit all the files online. So you do not send anything by email, and especially not by regular mail. You just submit all your applications, all your submissions, all your exhibits online, and each stakeholder, so the other side, the arbitrators, the arbitral institution, they're all informed automatically. So this is where technology plays a big role. But in my view, that is really just at a lower level. At a higher level, there is a lot of discussion at the moment to what extent AI, artificial intelligence, should be used in international arbitration. And that to me is the more important question. And I published a few papers on this and have been speaking on this topic several times. The big issue now is to what extent can I ask a computer software to decide on my behalf. Or I can put it more precisely or more concretely. Is it possible that I ask ChatGPT, what should I do? Obviously, that is not allowed because the decision must be by the arbitrator herself or himself. But me personally, I believe that artificial intelligence is a wonderful tool in support. For instance, if I have 1,000 documents and I would like to sort these documents in a specific order, or if I want to extract key information from all documents, this is where AI becomes a key supporter. Because if I do it on my own, then I can maybe do, I don't know, 20, 30 documents a day. So there will be a huge delay. If I have properly working AI, it takes me 5 minutes or 10 minutes. So some people say even that should not be allowed, but most people are of the opinion that these things should be allowed because it really helps the arbitral tribunal. But these are the discussions we are having at the moment. These are the main discussions. So technology certainly does play a very big role. Although, to be fair here, I have to say lawyers are often the last ones to adopt new technology. So I sometimes feel that we are a bit behind, but we're slowly getting there.
Okay, thank you so much, Prof. Khalid. Our time is up, and we are at the end of this event. On behalf of faculty, university, faculty of law, and also the notary program, I would like to thank you and for for providing extraordinary lessons. It's very insightful class today, and I assure that Professor Hart hasn't slept yet because we have 6 hours time difference. So thank you so much, Prof. Hart, and I believe participant right now is very happy to have you in this class. Thank you so much. If you come to visit Indonesia again, please stop by to Faculty of Law and also the Nursery program. We will happy to have you. Okay, that's all
Thank you
for
very
me.
much.
Thank you.
Thank you for everybody here. So we close the class and we will move to the other class and we have to take a break. And thank you so much and have a good one. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
I'll give you
warahmatullahi
to
wabarakatuh.
MC right now.
Right, thank you so much for Professor Sipel for sharing your brilliant and sharp knowledge within our first session. And a huge thanks to you, Mr. Wijaya, for leading our first discussion this morning.
Now, we would like to inform you all that we will have a photo session to mark the ending of our morning session. Please be advised to turn on your camera and smile. For the first slide, say cheese. Next, for the second slide, say cheese. For the last one, say cheese. Thank you.
Thank you so much. What a beautiful smile, right, Marcia?
Very beautiful.
All right, that marks the end of our morning session as we will continue the second session later today at 1 p.m. Western Indonesian time. We will leave you to have your well-deserved 1 hour break, and please stay tuned for more knowledge and insight by exquisite speaker in our afternoon session.
See ya!
Good afternoon and welcome back to Day 5 of Yarsi International Short Course 2024. After a brief break, we're finally back to guide you all through the rest of our amazing agenda. All participants, please be advised to turn your camera and once again stay inside the Zoom meeting for our afternoon session is about to begin.
Now, we won't hold you any longer. Let's go straight into our second discussion for today with the topic, the comparison of the contract law between civil and common law, which will be given by our speaker, Dr. Chandra Yusuf, SH, LLM, MBA, MMGT, and lead once again by our charming moderator, Mr. Dodi Wijaya. To Mr. Wijaya, the stage is yours.
Thank you, Andara and Marcia. Good evening, everyone. So finally, you see me again. And this is our last session for Yarsi International Short Course. And I'm very delighted, honored to be a moderator of Director Notary Program, Bapak Dr. Chandra Yusuf, SH, LLM, MBA, MGT. Dr. Chandra is not only a lecturer, but also he is a corporate lawyer and litigation lawyer with his experience practicing and studying in law in many countries. So our topic in this session, the comparison of contract law between civil and common law, will be addressed clearly by Dr. Chandra. Without further ado, I will call him. Please welcome Bapak Dr. Chandra Yusuf, HED, LLM, MBA, MGT. Times and place is yours.
Good afternoon. Assalamualaikum warahmatullahi wabarakatuh. Pak Dodi?
Yes, sir.
So we can start now?
Yes.
Okay.
Absolutely.
I will provide my PPT first. Just a minute. Okay. Thank you.
Yes, that's good.
Okay. I think I will start this last session of the short course. I will talk about the comparison of contract law between civil law and common law. Yeah, but before actually, before I just a minute. There's hello. Okay, I mean, if we talk about contract law, so we don't we will base on the system, legal system of the state or country. In this time, I will talk comparing contract means that we are comparing a legal system because the basis of contract is in the legal system. In this presentation, I will discuss the difference between civil law and particularly Indonesian civil law because it's different from civil law other civil law countries. We still have legal system, traditional legal system, traditional civil law legal system. It is back on the Dutch conqueror, yeah, but it's still valid until now, even though between the civil law and common law, both are derived from the European legal system and the English legal system. So the legal system related to the concept of law, of course, where the two things have an inseparable relation with each other. In principle, the legal system regulates the life of a society so that the conflict doesn't occur. Where if the conflict is inevitable, then legal system has an important role in resolving the conflict. The legal system in the world of justice has a major influence in the application of law, especially for judges in examining and deciding a case. And we will talk about the case later, yeah, because it's very important. The case, the decision for the case, and then the life of the decision will only end it by in the court only, or it will forever. I mean, it will follow by other judges as a law. That's the difference. But I will explain later. The panel of judges in deciding a case will definitely pay great attention to the legal system in the juridical area. In addition, the panel of judges uses the decision of other judges who decide cases whose substance is in principle similar to be used as a reference and consideration in deciding a case. Okay, and then we will talk the base or the base of the law. Yeah, I mean the basis, the legal basis of our law in civil code. Yeah, in civil code is back to Napoleon Bonaparte. They conquered the Dutch, and then Dutch come to us as a merchant, and then they enditnya, so they conquer us, yeah, and then uh, they implement their legal system to our society at that time. That's we call actually the legal basis for contract in Indonesian civil law. Yeah, is a perikatan in bahasa Indonesia, which can be found in its English equivalent as obligation. So perikatan or obligation is the basis of contract is set out in Book 3 of the Indonesian Civil Code. Book 3. The Civil Code because the Civil Code consists of 4 books. Yeah. The first book on person, the second book on things, the third book on obligation, and the fourth book on evidence and expiry. And the principle of contract, we will refer to pacta sunt servanda. We back to Roman's law. It means pacta sunt servanda means keep your promise. Keep your promise is a part of their corpus juris civilis. Yeah. And then they converse. I mean that principle to Article 13 and 38 Civil Code, yeah, in Indonesian Civil Code. In the Indonesian Civil Code, the principle is outlined in Article 1338 of the Indonesian Civil Code. We call it Bukerlik Wet Book, yeah, Bukerlik or BY, yeah, BY. By the Indonesian BW, sorry, by the Indonesian legal system, the 1945, we have a constitution 1945, an article that established the trias politica. So we have two system, yeah, before our independence and after our independence. And then after our independence is built, it's based on the Constitution 1945. So it's just like trias politica, like DPR, Dewan Perwakilan Rakyat, the House of Representatives will enact the law, yeah, the rule, and then the president also as I mean is as a executive, executive interest politica. They execute the rule that DPR made, or the House of Representatives made, and then after that, of course, the court, the Constitutional Court and Supreme Court. In addition, the article in the Constitution enforced the transition regulation. Also, at the time, at the Independence Day, we don't have any rule that valid at that time. So we have to make life of the rule on our before independence. So we have a transition regulation. So the DPR together with the president makes the law. The principle of keeping your word is found in Article 1338 Indonesian Civil Code because of aturan peralihan or transitional constitution. Yeah, Article 1338 Indonesian Code, which state that all agreement made legally become law for those who make them. This is a pacta sunt servanda, means pacta sunt servanda. And then principle dating back to the time of Kingdom of Justinian. It's a Kingdom of Justinian. They are very genius and very smart. They make a code. It's already they already have a code. Yeah, before Napoleon, they already have. So the Napoleon follow the principle. Yeah, the principle of the law that in Justinian, Kingdom of Justinian. Corpus, name is Corpus Juris Civilis, codification of Roman law. Yeah. Collected from 529 and 534 AD Byzantine Empire era. Okay. And source engagement, it means we call Kahwa Perdata or Indonesian Civil Code. Yeah. In Article 1233 of the Civil Code, state that all obligation or perikatan are created either by agreement, persetujuan, act, or by law. And then Article 1313 of the Civil Code states that agreement is an act in which or more persons enter into contract and bind themselves to one or more other person. Bind themselves is very important to show that it's very individual. So there is we will talk about the privity contract in common law system. It is the same as a privity contract. And And then agreement when sorry. So at certain talk about people who bind each other make an agreement. At least one person and one the other person is one on just two person together. Yeah, the principle because it's written into the article in the Indonesian Civil Code become adhesive and can be enforced by the state through a lawsuit in the district court because this is a private right. Kalau perdata or civil code is a private right. It's I mean a public rule. But when we make agreement between individual, so it will be our rule between the person or the individual who make the contract or agreement, but based on the article, based on 38, I talked about 1338 means so pacta servanda is a sort of the agreement. But in 1313 is about the engagement or about the obligation. Yeah. Talk about that person, at least two person together, make a engagement can be enforced by the state through a lawsuit because it is one person and one person. Yeah, they enter into contract and bind themselves to one or more other only by those person. I mean by that person. So no interfere from a country, from the state. So when it's problem, country enter based on Article 1313 or 1338 because it is private right through through enforcement, yeah, through a lawsuit in the district court. We said pengadilan negeri. In accordance with what John Austin said, it's like pointing a pistol at the back. So there is a sanction in this the decision of the lawsuit, yeah, for each other. Okay. And then agreement means written agreement, of course, written agreement. But actually, when I speak, I will use the sound like I speak now. I use the sound that come from the vocal cords, and then agreement on the alphabet is sound refer to the meaning of the sounded words. So I use alphabet A B C D until Z, and then we use grammar. We use words. It's sound and the sound. Yeah, and the sound refer to the meaning of the sounded word. The sound which is the alphabet floats in the air, and falls into the blank paper, then written, and then to be the written alphabet becomes the written word. When I read out what is written in it, the sound will be the same as sound I originally spoke verbally. That's mean that agreement can be verbally, can be written. It's just the same thing. But only for evidence, it's very difficult to prove the sound. And then a written agreement, considering written evidence, like in 164 has in Inslag Reglement or here, Agreement Article 1320.1 of the Civil Code, it's been kata or agreed, agreed between the individual, at least two individual, use thumbprint. We call it cap jempol, because it's only one. If every person have a thumbprint, it's very accurate. And then signature. Of course, is in the first time thumbprint is very classic, and then with finding the ballpoint and others, signature became more advanced. But when we come to technology, new technology, thumbprints can be the new one. Can be the new one with technology. I only use thumb for my absentee in Yarsi. For my absentee. Okay, and then the unwritten agreement that I said about the verbal agreement. It's a Greek word with sound. Okay. And then Article 1329 of the Civil Code states that every person is competent to enter into obligation if he is not declared incompetent by law. Is about the capacity of the subject, the party of the contract. It is if not adult, not with age. This will relate to immature and mature legal subjects as people who have the awareness or consent to do something. Age as a measure that can be said to be an adult. Article 30.2 of Indonesian Civil Code states that an adult or married person is the subject of agreement, even though the person is not underage, I mean, not adult or not immature, but because he's already married, so the law point him as a subject of a contract, even though he is under the age. And then written agreement, Article 1338 of the Civil Code states, all agreement which have been constituted legally shall be law to those having undertaken this. Indeed, pacta sunt servanda, or keep your promise here, is expressed in words that are more systematic, organized, and logical. I mean, the pacta sunt servanda is all in Article 1338. Cannot be separated. So why we should obey, and then a code is, and then because the code is valid, it's valid. Valid issue, the government can enforce it through coercion because, like I said before, there is aturan peralihan, that make a civil code is one of the public rule, and then this is the basis, legal basis for us to make a written agreement. So why we should obey a book? This is the question, the philosophic question. But we just believe, and we just believe that it is the voice of the people. So we follow it, follow it for the books, like the same like Quran, Hadith, and Injil. Okay, such agreement can be revoked. After that, such agreement can be revoked other than by bilateral consent or on grounds that are declared sufficient by law. So this is all together is pacta sunt servanda, can be separate. These agreements shall be carried out in a bona fide manner or good faith. We thought good faith means itikat baik. So this altogether is mean pacta sunt servanda or keep your promise. And then they convert it into Article 30, 38 of the Civil Code. The word all here, over here, all, it means freedom of contract. You can make any agreement. Yeah, it's not. It is your own. It is on your own power. I mean, power is individual. What you want, yeah, you can make it all agreements. Yeah, on all agreements. So which, but like I said here, the all indicate freedom for everyone to make agreement with anyone about anything, as long it's not prohibited by law. As long it's not prohibited by law. On Article 1338, um, this is all agreement. This means freedom of contract because it is individual. Individual can do anything he wants or she wants. Yeah. Okay, and then this is the freedom for everyone to make agreement with them, but it is not as long as it's not prohibited by the law. As I said here, at article stated here, that which have been constituted legally, which it means legal, as long as legal is not uh, uh, against the public rule and a public rule for people people is so the people is more powerful than individual or person. And then the word all indicate the freedom of everyone. Yeah. And this means that all provision in the agreement that have been agreed upon by the parties are binding. Parties are binding and must be implemented by the party who make it. Yeah. If one of the parties doesn't carry out the agreement, the injured party can claim compensation from the party who didn't carry out the agreement. Okay. Because the principle of keeping your word is expressed in the voice of the people of private right. Yeah, so it is the norm who followed by all people. Yeah, it is provision can be enforced by the state through the courts of judiciary. And then the praise lawfully made means that the praise lawfully made means that what the party agrees to is valid as law if it is not contrary to the law, public order, or decency. Yeah, it means to law, public order, we call in Indonesia ketertiban umum, and decency, kesusilaan. Yeah, if it is contrary to the contract, is null and void, batal demi hukum, is null and void. Yeah. Because I can say null and void because in Indonesia word batal demi hukum and dapat dibatalkan can be void and null and void is very different. Can null and void or can be void is very different. It is, it is again the article number 1320, point 1 and 2 agreed upon, and then the capacity of the subject, it can be void. But if people want go along with, and that's okay. Yeah. But different from suppose like a object is not clear, and then like I said, it's again the um, like a rule, and then decency and uh, uh, public. Uh, so it's we call it as batal demi hukum or null and void. Yeah. Okay. And then Article 3040, yeah, in our civil code, Indonesian civil code, this is what we call privity. Privity. Privity only people or person who might agree shall be binding. Yeah, agreement shall be binding as to all that is stated specifically by the term thereof, but also with regard to all that is required in line with the nature of such agreement or in terms of fairness, custom, or law. This is this article indicates that the only subject that are bound are the party that make the agreement. Yeah, this article said like that. Yeah, so because between the individual basically bind themselves, not bind by the rule, but bind themselves. Individual won't bind themselves. Yeah, between two people. Yeah, two individual. The agreement must be carried out in good faith. That is the desire of the subject to do something, then they enter into negotiation with other party. And of course, the desire is something good that has received an agreement contained in the content of the agreement to be obeyed by both parties as UN rule. Yeah, the contract is carried out in good faith. The party will perform the agreed action, rights, and obligation. And from this article, it can be concluded that people are free to make any sell and purchase agreement as long it doesn't violate the public order or decency. Yeah, this is as I said before, that as it's a freedom of contract, but don't violate a public order or decency or the rule. And in Article 1339 of the Civil Code, agreement is not only binding for things that are expressly stated in it, but also for everything that, according to the nature of the agreement, is required by propriety, custom, or law. Yeah, for example, when the party continue to perform their obligation while the agreement made has expired. Yeah, I suppose I export Malang apples from Jakarta, Indonesia to New York, yeah, USA, where the contract expired on March 22nd, 2024. But the contract still has the shipment of Malang apples left. So the party can still transact even though the contract um, has been terminated because the nature of the agreement is in the same as the contract. So this is not only in the written, because the written already expired, but they still can binding to finish the contract. And then Article 1320 Civil Code, Indonesian Civil Code, stated that the possibility of agreement require for condition as follows: consent of the person involved. It means that consent is when the people, person involved, yeah, and I mean kesepakatan, meeting of mind of individual. Yeah, individual have perception about our. Yeah, we talk about our. Function means refer to words. alphabet words, not the concrete, the concrete one. Yeah, consent is mean a meeting of mind. Yeah, yeah. We call it in Indonesian as kata sepakat, and that capability, as I said before, capability to enter upon agreement in means is already immature or immature or immature, but should be mature in the for the contract to be subject of the contract to enter upon agreement. A certain subject, I mean the object, object of the contract should be clear, and then a lawful purpose like we call it as we call sebab yang halal, a lawful purpose. Okay, yeah. A lawful cause, Article 1337 of the Civil Code, violating the law, decency, public order. I already said it is in Article 1337. 1337. Here, I already talked about the Indonesian civil law contract. Now I want to talk about obligation in common law system. So I can compare after this about the obligation between the common civil law and common law system. I have to talk about obligation in common law system also. The different civil code relies less on court precedent, because the common law system refer not to the word, but our civil code law, is referred to the words, to the language. But the different from civil common law system, that concrete even have more truth than arrangement with words abstraction. Therefore, the judge handling the case is authorized to decide cases that have not been regulated in written law. There is like a penumbra, like the empty. There is no rule. So the judge will make a decision, and they made the law for fulfill the empty. Civil code relies less on court precedent. Not we have like the Mahkamah Agung kasasi decision. We call kasasi decision is the final decision, final and binding, but not the same as precedent in common law system. Now, what is precedent? Means that precedent in law, a judgment or decision of a court that is cited in a subsequent dispute as an example or analogy to justify deciding a similar case or point of the law in the same manner. So previous judge make decision, and then after that the present judge will make the same decision for the same manner, for the same case, a similar case. This is the precedent. And at the end of the 19th century, the principle of stare decisis, let the decision stand. It means that the decision stand is let the decision before previous decision still valid for the judge after or present or on the future. So this is the meaning of stare decisis, become rigidly accepted in England. And then in the United States, the principle of precedent is strong. through higher courts, particularly the Supreme Court of the United States, may review and overturns earlier precedent. Okay. And then, so the judge made law, in case law, they have a sort of law. We only in civil code, Indonesian civil code, um, uh, only have from like I said, from written agreement, yeah, I mean, from the rule, like rule number 1, number 2, number 3, and all, and etc. Yeah, but only from the rule. Pure decision cash flow is pure decision cash flow, could be pure decision cash flow. And here, judgment law means whatever the judge use the reasoning or logical reasoning, means like suppose like uh, the what we call economic analysis of law. Posner make a judge based on the economic reasoning. Yeah, this can be used in the common law system, but cannot use in Indonesia. Yeah, because Indonesian always refer to the rule, written rule. Yeah, here they have a pure decisional cash flow. Yeah, and cash flow based on constitutional provision. So constitutional should be the basic legal basic here for the rule more lower. Yeah, cash flow based on statutory provision. Okay, there are 3 element of contract here is built on judgment law. Often is come not from like us from Article 1338 or 1320 or 1313 on Kahwa Perdata or Civil Code, Indonesian Civil Code. They come from judgment law. Yeah. Offer is element of contract. Acceptance also, consideration, intention, legal relation, lapse of time. That's why they call anatomy. They come from, they can separate together, but they should be together in one case, in cases. Okay. Just more. Okay. Offer, one of the party must have made an offer that shows his or her manifest interest in establishing a contract. Not every conversation is considered an offer. For example, some conversation may be inquiries into possibility of establishing a contract. I mean, we have agreement, or we agree together in civil code, but in common law, it's not always there is a between offer and acceptance. Yeah, acceptance. Yeah, there is there is a time, not always together. Yeah, not always together, but there is a time. I mean, between the offer, maybe the offer is 22nd, and then the acceptance is 23rd. But we are, our contact is together. Okay. Consideration also one of the element that judgment, yeah, the judgment. Mutual assent also kata sepakat, ya, or meeting of mind, ya, and then statute of roads, ya. Breach of contract is just the same. Breach of contract, we after well, I mean one prestasi, if something should do but you not do, and or you not do but you do, or deliver something, and it means you breach contract. Yeah, and it's that's should be the sanction. Yeah, it should be sanctioned over there. The legal standard for showing that a breach of okay, a damage also the same. Yeah, but the difference apart in planting agreement. Yeah, I mean, the basic contract, the basis of contract law is contained in the Indonesian Civil Code. Yeah. So contract is based on article, on the rule, but the common law adheres to the principle of precedent so that subsequent judges follow decision in the same case. The difference lies in the judge decision that has permanent legal force and the judge decision based on the ratio decidendi is followed by subsequent judge. So the judge make law that are applied in the same case. Yeah, civil law has minimal rationals and common law has abundant rationale. Both have their own weakness. Yeah. Now, common law prefer to like the civil code. They begin to implementing civil code is more practical because not such abundant ratio to is make the judge confused. So there is between the common law and civil law, there is a divergence and convergence in their own their own legal system. So um, better we have together have a either common law and civil law together. But we only have civil law. Like America has both common law and civil law. That's the problem on us in Indonesia. Okay, I think is my presentation. Thank you very much.
Okay, thank you, Dr. Chandra. So we have a discussion session. So everyone here who is going to okay. Sorry everyone, I just my connection is gone. So okay, everyone, if everybody here is going to ask to our lecturer, so please raise your hand. Nobody? Pak Chandra,
Yeah.
you can hear me well, Pak Chandra?
Yeah, you hear me?
Okay, okay, yes. Okay, Pak Chandra, would you like to describe us why a common law system, they always say that their country is unwritten law, but actually when I was studying in United States, we were both studying in States. Uh, they have like the act, and also they have a constitution. So it means that not really unwritten. They still have the written law. But why a common law system? We call it as a unwritten law. Maybe you can describe more.
Okay, thank you. I think uh, uh, this is the different. We have to know one country. Sometimes one country has two systems. Like United States, they are conquered by English, by English and by also by French together. And they have like Louisiana and then other part of their state. Um, it is a civil law system, and then uh, others is common law system. But they mix together between law and civil, common law and civil law system. So they have two systems work together. That's why they have parliament. Parliament, it's mean just the same like Bonaparte. Yeah, they have a parliament like we call like DPR. Yeah, like the same like DPR.
Congress,
So
right?
yeah, so they have mixed system, the mixing between common law and civil law. Now, American uh, uh, are more preferable to civil code. Is begin it begins more simple because too many rational to book or rational or ratio descendi, or we call it precedent, or we call it also the logic is too much for making a decision. So better we go to normative, just accept the norm in society and not use like a philosophy or use and other logical things. Even though like Richard Posner use the logical economic logical, it's very logic, but it's okay. I think I think it is also rule. Like we have ATM, we don't have a transaction like just like the same in the traditional way, but it is a transaction also, and no rule at all. Okay, yeah, I think
Okay.
it's together to make the problem is Indonesia doesn't have only one. They don't have. I mean, may they just have an intra fund wisdom, but it's only one decision only. Yeah, they don't. After the decision, the judge doesn't follow their decision, their case. Yeah, even the similarity, there is a similarity, and then the same element, they don't follow it. Okay,
Okay.
that's my.
Okay. Thank you, doctor. So anybody here who can ask? Okay, Muhammad. I see
Hi.
one
Yeah.
participant raise hand. Muhammad.
Yeah. Hi.
Muhammad. Okay,
Hi.
sure.
Can
Please.
you hear me?
Yes, yes.
Okay.
We hear
Salam
you
Pak.
very well.
Yeah. My name is Muhammad. I'm from Malaysia, so I'm from a tradition of common law, and I'm currently studying in Sydney. And in fact, we are going to have our iftar right now. So a quick question, just because you have done a comparative study between the tradition in civil law and also common law, in which I am not very familiar in civil tradition. So I just wonder if that is there any practical difficulties for any Indonesian contract in your life when you are dealing? I mean, when Indonesian counterparts deal with other parties that came from common law tradition. I just wonder, is there like any practical difficulty that you have experienced in dealing with parties came from different traditions?
Sorry,
Okay.
Thank you.
you are asked too fast. Can you
Oh,
repeat it?
So,
oh,
Doctor,
sorry.
Please
yes.
slowly.
Okay, so I guess my question will be: is there any real difficulty for Indonesian contract when dealing with uh, counterparties that came from common law tradition when we are
Okay.
signing contract in Indonesia?
Okay. Thank you, Muhammad.
Yeah, thank you.
So Dr. Chandra, Muhammad said if Indonesian, if doing a contract with people that basically in common law countries, so is there any difficulties that you maybe face in your expertise, in your
Yeah,
experience?
yeah. Actually, because in contract we have one form. Yeah, with one form is together. Also, because even one person is come from common law and one person the other is from civil law. Together is in one form, yeah, one form of the contract. But actually, they like a fourth major. I have a problem here. Fourth major. If we have a choice of forum, choice of forum, like the previous speaker said, forum is arbitration. It's okay. Arbitration, not the pointed legal system. Yeah, but if we use a legal system in one of the party, yeah, and then legal system, and then it will be difficult if we use like a fourth major. Fourth major, they don't recognize fourth major in common law. Yeah, they don't recognize. They recognize hardship or in United States the doctrine of frustration, suppose like that. Yeah, the doctrine of frustration. If you bring the fourth major, yeah, the term fourth major in contract to their court, they will not recognize it. It's very difficult. So it doesn't match their rule. Yeah. So they have doctrine of frustration is supposed like economic, also one of the reason. Yeah, for the doctrine of frustration, but not in us. In Indonesia, like a fourth major, more to from I think 12, 40, 40, 44, and 12, 45. It's like act of God. Yeah, so it's absolute. You can do nothing, but in not in economic, like in civil law country, in common law country. And then the second one, I have the difficult, um, the English, because the English is actually common law system language. We Indonesian not is more natural language. We then, if we use English, so we refer to common law system when we meet the principle of the law, uh, and then it's very difficult. Like offer and acceptance is different from agreed upon, and between I mean perikatan like obligation in our civil code. That's the difference. It's actually also we need Indonesian language. If in Indonesia, if party choose Indonesian form or Indonesian court, it also will be difficult when there are bias in language between Indonesian and English. So if we use the column like I said on Tim Lindsay yesterday, so there are uh, two two contract Indonesian and English because it's different meaning in Indonesian, and you can use directly the word in English to Indonesian or Indonesian to English. That's the difficult that we face at this time. Okay, I think that's my answer.
Okay. Thank you, doctor. So, anybody want to ask more? Maybe nobody. So, if nobody going to ask another question, so maybe we can close this session. Pak Chandra, is it okay?
Okay.
Okay. So before I close this session, because this is our last session, please turn on your camera so maybe we can take a picture together. So I can see your smile and also I can see your face that so I see the Tanya's smile. Okay. So everyone, wow, in Desi Ernawati's account, that's like a party together. As I see Mbak Suci, I see Muhammad Ridwan Erlangga, Muhammad in Sydney. So everybody can turn on the camera. This is our last session. So at least we can see face to face. If you have any activities in Jakarta, please stop by in Faculty of Law and also in Notary program at Yarsi University. I really welcome to everyone here. So please, slide one still a lot of a lot of people who turn off the camera, and I see slide second. Okay, that's good. There is a Profrudianti. Uh, and slide three. Come on, slide three, please. Only Desi and friends. Okay. Operator, ready? Please take a picture together. Give your big smile and say cheers. Cheers.
Cheers.
Okay. Slide two. Say bunkies. Bunkies. Slide three. Please say Maci. Okay, thank you so much, and I'm happy here, very delighted,
Thank you
very honored
all.
to know. So I hope that we can see in another activity. So thank you, Pak Chandra. Thank you,
Thank
Dr. Chandra
you. Thank you.
Yusuf,
Thank you.
for
Thank
very
you all.
insightful uh, lecture today. And that's all for me. If I have any something wrong as a moderator, and on behalf of Faculty of Law and Master of Notary program, I would like to thank you for everybody here. and I got the time and place to the MC. So please, Marsha and Anda, time is yours.
Thank you so much, Mr. Wijaya. And I will say thank you, Dr. Chandra, for sharing another insightful knowledge within your area of expertise in our second discussion. And another massive thank you to Mr. Dodi Wijaya for leading it. And with that, Yarsi International Short Course 2024 has to come and to end. To close out our valuable day, let's recite Hamdalah together.
Alhamdulillahirabbil alamin. On behalf of our entire team on duty for today, we would like to sincerely apologize if there is any mistake or inconvenience in the making and execution of this event.
I'm Adara Aule Haryadit, and here's my partner,
Marsyani Solia Rahman,
as your Master of Ceremony on day 5 as the Faculty of Law and Master of Notary Program of Yarsi University International Short Course 2024, would like to say a huge thank you for your precious time and kind attention.
And may Allah bless you all who follow this event from the first until the last day with the knowledge you have gained from this series of events. And see you in another exciting and insightful event in the future. Wassalamualaikum warahmatullahi wabarakatuh.
Recording stopped.